Welcome, Tristan. Welcome, Nikki. Esther, welcome, welcome. Whoever in is, welcome also. It's great to have you guys here. This is great. We're going to have fun tonight, like we usually do. Tonight, our producer of this program is Ben. Dan is at an educators convention. And so Ben is with us tonight. He'll be handling all the technical aspects of our program. And it's great to be here with you tonight. So before we get started on our questions, does anybody have any questions about any of the material? This is your chance to ask a question right from the beginning. Thanks for saying hello, Esther. Anybody have any stuff? Okay. Ben, let's hit the first question then. This is what you don't want to happen to you. You don't want to join a brokerage company and then have them close up. And probably not going to happen right now. The market's good and brokers are making a couple of bucks, and agents are making 4 times that. So it's a good time to be in the business. But if a brokerage closes, what must they do to comply with the division requirement to keep records for 3 years? That is the question. And the answer is A, they must notify the divisions where the records will be kept within 10 days. That's warm and fuzzy. Hang on to that one. B, they must deliver the records to another active broker. C, they must deliver the records directly to the division. Yeah, like they want to store all that stuff. D, if a brokerage closes, they no longer need to keep the records of transactions. No, the requirements specify, and the correct answer is A. They must notify the divisions where the records will be kept within 10 days. Now, do the records have to be kept in the state of Utah? No, they don't, but I had a broker close her shop. A friend of mine, I worked for her for, I don't know, 2 or 3 years. I was her top producer, but she and her husband got divorced, and she decided she wanted to move to Washington State, but she had to let the division know she'd be taking her records with her. They said, well, you have to keep them here, but no, they don't specify that in the rules, but they just have to know where they are. And within 10 days, almost everything you're doing with the division is within 10 days. You know, you change your name, you got to let the division know within 10 days. You do almost anything, you have to let the division know within 10 days. That's change your address, that change brokerages, whatever you're doing, it's pretty much 10 days. That's a really good thing to remember. Next question, please, Ben. What is a principal broker required to keep in the transaction files? Referrals from the client. It's always nice to get referrals, but I don't think that would be a requirement. Would you? Signed agency disclosures. Ooh, hang on to that one. Signed thank you cards. Polite to send out a thank you card, but probably not something they would regulate. A list of agents in the company. Well, the division already has that. They have in their computers. So what do you think the broker has to keep in their transaction files? This is a pretty easy one. The correct answer, of course, is signed agency disclosures. And signed by disclosures from both parties. And there's lots of different disclosures. There's an agency disclosure. There's also property condition statements that could be considered a disclosure. But they have to keep copies of all that. And they have to keep that in the file. Now, the broker is required to keep that for 3 full calendar years following the year of the transaction. So if you had closings in December, it's going to be like, 3 years and a month, right? But if you have closing in January, February, it's going to be almost 4 complete years, 3 full calendar years following the year of the closing. And that's another wake-up item for you on the test. Okay, Ben, next question, please. If a closing takes place at a title company, who's responsible to ensure that the settlement statement is accurate? Title agent, sales agent, mortgage broker, principal broker. Correct answer, guys, is the principal broker. Now, the principal, yeah, that's right, Esther, it's a D. The principal broker is responsible for the accuracy of the settlement statements. Now, the interesting thing is the principal broker in practicality doesn't prepare these. More often than not, they're prepared by the title company, of course. And but the broker should check those over, and the best time to do that is prior to the closing. But usually they don't get around to it until after the settlement's already been handled. And if they find a mistake, they got to run around and get it all straightened out. But you do see mistakes. Having been a broker for over 40 years, about 43 and a half years or so, I've been to thousands of closings. I've run really big companies that had 120, 150 agents in it, and I've run companies with just 10 people in it. But I had a lot of my own closings, been to a lot of my agents' closings, been responsible for thousands of closings. I always like to look over the settlement statements before they close so I can, fix a problem if I catch it, and there's a lot of them. A lot of them are caused really because the agents don't give proper information to the title company. One of the main ones that happens that the title company needs to know if that property is rented or not, because they're going to assume that it's just occupied by the seller and not rented. But if it's rented, if it's a rental and you're selling it to a buyer that's going to keep it as a rental, or maybe they're going to, eventually get rid of that tenant, move in it themselves. I don't know, but the point is that there's additional issues that must be addressed on the settlement statements. But if the title company didn't even know it was a rental, I mean, they just missed it entirely. So you really have to give the title people a complete background of everything that's happening in that transaction so they could do their job correctly. I used to go to all the closings for my new agents. I like to go to their first one or two closings so that they were more comfortable. And then we would take those settlement statements after the closing, and I would go through them again with just the agent, so the pressure's off by then, and then explain to them how they were done and why it was prorated that way and whatnot. Okay, does the buyer have to honor a what? I can't see the rest of it. Can you see that, Ben?
Yeah, does the buyer have to honor a rental agreement or a lease?
Absolutely. Yeah, that agreement survives the sale. That agreement gives the tenant a right to be there, and that right doesn't end at the sale. Tenants have rights, and they survive a sale. Now, so let's say there was 3 months left on a 1-year lease or something, then the owner would have to honor that. Now, the tenant is also obligated on that lease as well. A lot of properties are purchased, particularly investment properties, because it does have tenants. You look at a large commercial building that's completely full, and you have the money to invest, 10 million, 8 million, $5 million, whatever that building might be worth. You're paying that price for that building because of the cash flow the building generates. Last thing you want as an investor is to buy that building and then have all the tenants leave. Now your building is empty, and you shouldn't have paid $5 or $10 million for it. So those leases endure a sale, and it doesn't have to be a complete sale. You can just say, you might have someone that just buys half of your partnership. So, you got to think a little bit beyond just residential. But even in residential, the tenant has a right to stay there. Excellent question. Thank you very much. So S just signed a listing agreement to sell their home with their real estate agent. The next day, their broker, who was a sole proprietor, dies. Well, that's unfortunate. What must S, that's the sales agent, do to continue working, or what must S, who is the owner, sorry, what must they do in order to continue working with that agent? Well, when you have a question like this, I suggest you read the stem of the question twice. Now, in this one, they've got a little trick in here. It says the broker is what? They're a sole proprietor. If a broker is a sole proprietor and they die, their license dies with them. And immediately all the agents are put inactive. So let's look at our answers and see which one fits. A, the seller could sign an affidavit that the listing agreement is still valid. No, that doesn't work. B, apply for an extension of their listing agreement. That doesn't work. C, nothing. They may continue with the agreement with the agent as if nothing had happened. No, that's not right either. I give a buzz to that. The correct answer is D. They must wait until the agent affiliates with the new broker, then renegotiate a new listing contract, a new listing agreement. Okay. And the trick there was that broker was a sole proprietor. Now you look at brokers, well, like when I was running offices at 150 agents in it, we would have, maybe 80 to, sometimes 250 listings at any one time. And I was the broker. If I died, what would happen to all those listings if I was a sole proprietor? It'd be absolutely devastating. So when you do go to work for a broker, a legitimate question to ask them would be, how is your company structured? If they're a sole proprietorship, hopefully, they're going to survive, and they could be in great health and still have a horrible accident. So most brokers are not sole proprietors. Most brokers incorporate, or they're a limited liability company. They're an LLC, but there's some type of entity, because the entities are non-breathers. They don't die. So there is a company license, which was attached to the broker. But in this case, if a broker did die and they were an entity, the brokerage firm was an entity. It was an LLC. It was a Massachusetts business trust. It was a corporation, a non-breather, but it was a legal entity. Then what happens is the division will provide, or they don't provide, but they will recognize a reasonable period of time when a new broker could put their license into that company, because the company didn't die. So if you're a heavy lister, it's important to work for a company that's an entity, because you don't want to lose all your listings. You lose your listings if the broker is a sole proprietor and the broker expires for whatever reason. Okay. Okay. Somebody had a question. Ben, what was that? Did you catch that?
Yeah. So does this mean the contract between seller and agent is still valid, or could the seller get out of the contract?
Well, no. What happens is the contract is not between the seller and the agent. I mean, that question made it sound like that, but it's not. The person that owns the listing is the broker. It's a contract between the broker and the seller. So when you list a property or you list a buyer, that they're signing up with the broker, not you. I mean, it goes principal, agent. The principal is either the buyer or the seller. The agent is the broker. Even though they're the broker, they're still, as far as agency goes, they're the agent, and then you're the sub-agent. So there's someone between you and your client. Now, the truth is, your broker probably will never even meet your sellers. I used to wander around and meet all the sellers as much as I could, even when I had the large companies, and knock on the door and tell them how lucky they were to have that agent, just to kind of reinforce that for the agent a little bit. If I happened to be in the area, I couldn't get them all, but I tried to get a lot of them, and tell them I was a broker and give my card and tell them they could contact me directly if they had any questions. But, but their agent was fantastic. And but it's, so if the broker dies, your listing's gone. Now, if it's under contract, meaning that your listing got sold, I mean, a buyer came, they wanted to buy it, the buyer and seller agreed. Now you're in the executory stage and the broker dies. The division allows that contract to be finished, because it's already an agreement between the buyer and the seller. It gets a little dicey there, but it doesn't happen that often anyway. So we kind of work through those. But you're going to have to affiliate with the new broker, or most likely the broker is an entity, or he has an entity that actually has a company license. And if the broker passes away, then they find another broker that will come in and step in and take over that company license, and everything's fine. But if they're sole proprietor, that was the key on this one: sole proprietorship. Next question, please, Ben. Okay. Compared to a sales agent, an associate broker, A, has more authority, B, has less authority, C, has the same authority, or a D has no authority. Well, there's really no difference between a sales agent and an associate broker as far as authority goes. So the correct answer to this one is they have the same authority, C. Okay. Now, authority is kind of a heavy word, but they have the same responsibility as well. Just because you have a broker's license doesn't mean that you are the broker for the company. Currently, I'm an associate broker. I'm not a broker for a particular company, but I do have a broker's license. So my privileges and my responsibilities, or you might say my authority, is the same as you guys who come in as a salesperson. And you come in and as with a sales license, and you can work for 3 years minimum as a sales agent, and then you accumulate points depending on what production you're actually doing, whether it's leasing or selling or what type of real estate activity. You're given different points, and when you take your exam, you've got to have you've got to have a good handle on how many points you get for transactions and stuff. So, but they have to ratchet up to a certain number. When you hit that number, then you can go out and you can actually take the broker's test. You have to take another 120, and then you take the broker's exam, and then you can become an associate broker. Do you get a higher commission split? No, not necessarily. Commission splits are done by contract negotiation or a volume of a business that you might be doing, not by what status of license you have. So what's the big deal? Why would you become an associate broker? Well, one thing, it's cooler than just being an agent. I mean, we have about 40,000 agents in the state right now, but we only have less than 2,000 brokers. So it's kind of cool. It gives you a little higher license status. You don't get to do anything different than an agent does. You're just an associate broker with the firm, but it does allow you to walk out the door anytime you want and start your own company, because you're ready to go. You have a broker's license. And so you change from associate broker, principal broker, or you could also become a branch manager. The broker feels like he or she needs one in a certain area, wants to open a new office, and you have a broker's license. Or in a case before, where the broker actually died, you're working at the firm, you're familiar with all the policies and procedures and whatnot, then, that's cool. I mean, you might step right into that principal broker's for a long time or a short time, but it's nice to have a broker's license. Strongly suggest it. It also makes it easier for you to get licensed in other states. If you walk in as a salesman, it's a little more difficult because you're going to have to affiliate with another broker and whatnot, and find another broker. But if you have a broker's license in Utah, some states have a reciprocity where you only have to take the state exam. You don't even have to take any educational hours. And then you can get a broker's license in another state. I used to be licensed in Utah, Montana, Nevada, and Colorado. I've let all those other licenses go. I'm just licensed in Utah right now because I have a little different situation with the broker I'm currently with. Okay, any questions on this one? All right, let's go to the next question, please.
There was one question, and that is, don't you get more of a say with the decision processes within the brokerage?
No. What gives you more say and sway around the office is your production. I mean, if you're only doing a dozen deals a year, hey, you're still making great money with the prices in this market, but still, you're not going to have near the authority in the office or power in the office as someone's doing 50 deals a year, or 100 deals a year, so it's all based on volume is what really gives you the power in the office. Broker doesn't want to lose you. The broker doesn't want to lose anybody, really. I mean, even if we're only doing a half dozen or a dozen deals a year, that's still important to the broker. But if you're doing, high volume, that's what's going to give you more authority of what goes around the office. It does give you a deeper understanding in the business because you have to go through all those hours again, and the classes are on a higher level. The test is a little more difficult. But by that time, after 3 years experiences, you're going to know more too. I strongly recommend you get a broker's license. Hey, not only that, but we could use the tuition here at the school again. Come back to the school. Next question, please. Okay, now what about a broker who gets in trouble? If a sales agent's broker has their broker's license suspended, what must the agent do to continue the practice of real estate? A, they have 30 days, to do something, continue working and finish up deals. B, they must get their broker's license. Well, they may not qualify for broker's license. That's not a good answer. They can never again practice real estate. It wasn't your fault the broker got suspended. I mean, if they did, if it was your fault, you're going to know about it because you would have your license suspended also. Or D, they must activate their license with an active broker. And of course, that's the right answer. You got to go find someone that's okay with the division because your broker doesn't have a license anymore. Whoops. And, you don't want that to happen. Okay. Questions on that one? Great. If a client wants to collect interest on the money that they give to their broker as earnest money for a transaction, what must they do? $1,000, $1,500 earnest money, they're probably not going to care, particularly at our ridiculously low interest rates for, what are you going to get at the half of a point? It doesn't make any difference. But if you're putting up $50, $100, $200,000 in earnest money, you might not want that to sit there for a while. I got a commercial deal under contract, 1.7 million right now. It's a former Village Inn restaurant up in Ogden, and supposed to close in August, but we've had that sucker under contract for 9 months now, working through all the details on the sale. And they have 50 grand in earnest money, and it's in a non-interest bearing account, but if you put a ton of, interest is so low right now, when interest is higher, it might make more sense. So anyway, a client wants to collect interest. What must they do? A, the interest earned on the earnest money goes to the winning party in a contract dispute. Okay, I don't know, sounds compelling, but not real compelling. B, they cannot collect interest on money unless they have a written permission from the clients on both sides of the transaction. Yeah, that sounds good. Trust accounts are not allowed to accrue interest. And D, they must have a meeting of the minds with the other party and settle it with a handshake. You don't settle anything with a handshake. Everything has to be in writing. So out of all those, we could definitely eliminate A and D. So we're looking at trust accounts are not allowed to accrue interest. Trust accounts are not allowed to accrue interest unless they do, which the only way they can do is by doing B. They have to have written permission from everybody in the transaction on both sides of the transaction, including who the interest goes to. Because both of them are going to claim, that, well, so I was going to say, well, you took my property off the market for 9 months, I should get the interest. And the seller's going to say, well, no, the money is mine until it's yours, and it's not yours until we close. So I want the interest. Now, there's one other thing you can do. It's just not happening right now because the interest rates are so ridiculously low. And that is our state does allow, with everyone's permission, the buyer and the seller, that you could have the money put into an interest-bearing account, and the interest on the money earned on the earnest money would go to a housing charity. And we have one set up in the state. And back when we had 8 or 9 or 10% interest rates, and on savings accounts at least 5 or 6, we generated a considerable amount of interest for home Habitat for Humanity or other types of home type charities, and it was a great thing. But today, even on the interest rate on a mortgage loan, I saw one brokerage company this week that was advertising on a 15-year loan, 1.75, under 2%. Talk about a giveaway. Even 2 and 3% is a giveaway. I've sold homes in 12% markets. Yeah, figure that out. Okay, next one, please. Okay, a Utah broker must have a trust account established in Utah. A, if the broker resides in Utah, because you can be an out of state. Like I just mentioned, I had licenses in other states and I lived in Utah. You can live in other states and have a license, a broker's license in Utah. The state allows that, but you have to have a broker's, your account here. You must have an account in Utah for your earnest money. B, if the broker does not reside in Utah, no. If the broker has an office in Utah, well, no. Whether or not the broker resides in Utah or has an office in Utah, they must have what in Utah? And the correct answer is a trust account. So, you just, on a lot of this Utah law stuff, folks, you either know it or you don't. So the only way to know it is to really work and focus on those practice exams, and then go through the material. That's assuming you're more of a visual type learner, which many people are. But if you're an auditory learner, we do have a number of classes on Utah law where you can actually, that are pre-taped, that you can watch on demand and kind of listen to those, and of course watch them as well. But that are very, very helpful. When you go to take your test, you guys know that there's a national portion and there's a Utah state portion. You must pass each portion independently. So you can pass national and flunk Utah, and then you have to come back and retest, but you don't have to take the national again. You can only have to take the Utah law. Now there is a deadline on that. You can't stretch it out for years, or even a year, but I mean, you need to get back in and get your exam done. But if you passed half of it, that's great. You're halfway there. There are more questions on the national portion. That's about 80, and then there's about 40 questions on the state portion. So next question, please, Ben. Jay is buying a house, and they want to give a promissory note as earnest money. Who should they make the note out to? Now, this is pretty much always on the exam, guys. A, the seller, B, the buyer. Why would they make the note out to themselves? C, the agent. I don't think so. Okay. D, the broker. Okay. So eliminate the middle two. We've got the seller or the broker. What do you think, guys? You have to make it out to the seller. I mean, who agreed to take the dumb note in the first place? It's the seller. If the note were made out to the broker and there was a default and the buyer owed the earnest money, if they're, stand-up people, they're going to rush right down and write that check for $5,000 and pay that note off, right? Yeah, well, unfortunately, in the world we live in today, I have found that integrity kind of wanes out at about $1,500. If it's 1,500 or lower, they may probably do it. They'll complain, but they'll probably do it. But if it's over 1,500, you're probably going to end up in court. Now, the problem is, if the note was made out to the broker, who has to sue them? The broker. Well, who agreed to take the stupid note in the first place? When you brought in the offer to the seller and you said, look, folks, the earnest money is only a promissory note. These things are really difficult to collect on. And even if you take them to court and get a judgment against them where the judge says, okay, pay that promissory note, they still may not pay it. So you're going to have to end up trying to garnish their checking account or, garnish their wages, go through a whole collection procedure. And even getting through court on the note, let's say it was a larger note, $10,000. Well, you can't take that to small claims court. You have to go to district court. It takes 3 years to get in there. and about, I don't know, probably $15,000 in legal fees. So, it's just, you met it after the seller, and then when they default, you take the note over to the seller. Your broker will go with you and say, well, here's your note, go ahead and sue them. Hey, let us know when you're going to court. We'll show up as witnesses. Okay. Promissory, but no one's going to take a promissory note right now. The market's too short on inventory. There's multiple offers on everything. Somebody in that group of 10 people or 5 people that are trying to buy that house is going to have a large earnest money, and it's going to be put right into the trust account. So if some guy's trying to buy a house with a promissory note, forget about it. Don't work with buyers like that. They're not real. Now, in a shorter market, or in a market where you have tons of inventory and people are desperate to sell and you have very few buyers, totally the opposite. You can do promissory notes. You can do all kinds of things. Okay. Okay, Ben, what's Lindy's comment? My thoughts exactly? Okay, fine. All right. In order to distribute earnest money, a broker must have A, written permission from the buyer, B, oral permission from the seller. Guys, oral permission, everything's got to be in writing. Throw those out. Okay, C, written permission from both buyer and seller to distribute the earnest money. D, the broker can distribute earnest money at their own discretion. Now, this is a very tricky question. And the reason we're looking at it in depth right now is because you're probably going to see it. Does that make sense? Okay, great. The correct answer here is C. You must have written permission from both the buyer and the seller. Now, one place where the contract is defined is the real estate purchase contract. It's in the contract itself. And in the contract itself, which is signed by both the buyer and the seller, there are provisions for default. And in those provisions for default, it says that the broker can distribute their earnest money if, in their opinion, one of the two violated it without getting any further written instructions. Okay, but the only way a broker could do that, the only reason why they can do that, is because it was in writing, and he was given power or permission from both the buyer and the seller in the real estate purchase contract. So when you see this one, don't sucker for D. Okay, it's C, written permission from both the buyer and the seller, and that written permission comes from the real estate purchase contract. Okay, kind of tricky, but not so tricky now for those of you that are here tonight, because you're going to remember, oh yeah, that's that one Rick was talking about. Cool. I'm glad you're here. Okay. Thank you, Ben. A brokerage sets up a temporary branch office in a model home, usually in the garage of the model home. Okay. They do not need to register with the Division of Real Estate unless their branch office will be there for more than how long? 12, 6, 1, or 18 months. What do you think, guys? What's your guess? That's right, Nikki. It's 12 months. Perfect. 1 year. Okay, so if it's 11 months and and a half a month, 11 and a half months, no big deal. So if it's going to be longer than that, the division may, they want to, if it's going to, the thing is, it's set up as a temporary branch office. It's not just people showing up and there's brochures in the garage and there's a place to greet people when they come through, and it's not manned all the time. That's not a branch office. That's a for convenience office in a model home. But the division was uncomfortable with that. So they said, well, we got to put a time limit. So they put 12 months on. And in this fast market, unless you've got, 500 homes to sell, it's probably going to be just fine for most of the smaller subdivisions we see, around 12 months. At least on the test, that's the way you're going to answer it, right? Okay, and then the next question, please. Why is purchasing a home for D? Okay, who's out of the country? Maybe they're in the service, but they're out of the country for one reason or another. So D gives Y a power of attorney so that Y can complete the transaction in D's absence, which is true. Y does not need a real estate license. That's true. B, Y needs a real estate license. Okay, so that's diametrically opposed. Both can't be correct, but A is true. What they're doing is illegal. I mean, with digital signing and everything today, he could just sign it digitally almost anywhere he wants to in the world. But sometimes people get a little leery of doing that, so they ask their attorney to attend a closing, or they ask their brother-in-law who had a license or owns a lot of property and smart, to go in their absence. Usually you don't see people showing up with power of attorneys on the buyer's side. You usually see them showing up on the seller's side. Why? Well, because most buyers are getting loans and the lender isn't going to let somebody else sign that loan document or documents. Actually, there's a whole stack of them. So you might see this more on the seller side, but the correct answer is A. Now, why not need a license? Well, because they have a power of attorney. Power of attorney allows you to act for someone else. You become what's called an attorney in fact. And you can be there and sign the documents. And when you sign, this one was D, right? So you would sign it D by Y, who's acting as a, oh no, it's actually the other way around. Y is purchasing the home. So you're signing Y by, you're signing a Y, okay, by D acting as a power of attorney. And then, of course, they're going to have to record that power of attorney into public record as well. Okay. To prove you have the authority to sign for that. Okay. Fun. Okay. Any questions on any of the material we were talking about tonight? This is your chance to participate. Okay. York, welcome. Chime on in or chat in, either way. Okay. Okay, about any topic tonight.
Hey, nice to hear from you, Rick.
Thank you. Do you have a question about any of the material?
Nope, I'm just following along here, taking notes. These are great
Okay.
questions.
Great. In the past, I've mentioned to you guys that, well, first of all, let me say, you can do this. You can get through this exam. Come on, it's a multiple choice exam. You don't have to know the right answer. You just have to recognize it. You got to just pick it out of a lineup before. And by going through the reviews like tonight, by understanding the material, you're going to be okay. Ben, what's Nikki's question?
On the test, does it give you the math equation to use, or do you need to memorize the equations? There's
probably only going to be about 6 to 8 math problems. They're all going to be on the national portion of the test for the most part. On the state portion, you will be looking at a settlement statement, but it's kind of like, they're going to give you a settlement statement. I mean, it's kind of like, okay, here's a crib sheet, okay, and so and the right answer is on there. So there'll be a question. It'll say something like, who paid for the home warranty and how much did they pay? Well, you just got to find it. It's on the crib sheet. It's on the settlement statement. So that's not really math. That's just finding an answer on the settlement statement. And hopefully it's not the first one you ever looked at before you stepped into the exam. You need to work with it a little bit, but it's more about being able to find it on that form than it is anything else. So in the national portion, they're going to give you some math problems. Now, because there's only 8 math problems, okay, pretty much that's all you're ever going to see. And because of the fact that you only need a 70%. Now on 80 questions, if you could miss 30%, what's 3 times 8? Math geniuses. Some of you gonna have problems with math, okay? You can miss a whole lot of questions. In other words, you can miss every single math question and still pass the exam. Now, I don't recommend you do that because a math question is something you can definitively know exactly that you got the right answer. But you need to know how to do the formulas. And we have whole classes on that. And, if you're a math phobic, we're not going to change that, but we can get you through the exam and at least get 75% of the math questions, because they're not that tough. You just need to work with them, and we have whole classes on that. Great question. I really appreciate that one. Okay, you will pass this exam. We have the highest passing rate in the whole dang state. I mean, we've had many months where 100% of our students pass the test, and I'm not supposed to say that, but I don't own the school. But it takes effort on your behalf. Don't stretch these classes out over a year and a half and then think you're going to remember everything. Try to get in as quickly as you can and come to the review classes. And you're welcome to call me. My number 801-556-8000. That's 801-556-8000. That's my cell phone. You know, it's right over here. I answer it myself. Now people say, well, I don't know. I get text, you know, is it okay if I call you? Pick up the damn phone and call me. You know, don't send me a text saying, is it okay? It's always okay. If I don't answer, well, it wasn't okay. You know, but most of the time I answer, and, you know, if I'm at a church meeting or something, I probably won't answer the phone, but, you know, but it's pick up the phone and call me, day or night, doesn't matter. You know, just give me a call. We'll spend a quality 3 or 4 minutes on the phone and you'll understand it. I promise you, it really, really works. You need extra help, just give me a call. And if you're in big trouble, you know, then, you know, we might even do something else. You never know. I meet with students all the time. We usually meet in a Regis office. They're all over the state, and you know, they're very comfortable situation. I have a contract with them that I can use their facilities anytime I want, and well, if they're open. And you know, sometimes I've spent hours cramming students. You know, no extra charge. I care about you getting your license. I care about you making money. Now, in the past, I've told you that this is a head game. And what I mean by that is your attitude is everything. You will pass the exam. You can pass the exam, and you can make money in this business. And people say, oh, well, the market's so crazy. The market is always crazy. It's always a seller's market or a buyer's market or a mixed market. And sometimes it's a severe seller's market like it is now. And, you know, and sometimes it's a severe buyer's market like we had a few years ago. And sometimes it's just kind of mixed, you know, but it's rarely ever going to be a market where you have the exact number of homes, the exact number of buyers, and everything just fits just perfect. And guess what? You know, everything just worked out fine. You know, it's in markets like this where buyers truly need you. Why? Because you're going to have to direct them on how to write really great offers that are compelling and can be accepted. They're going to have extra money because they're probably going to have to pay over the appraisal, and they're going to have to eliminate some of their contingencies. Don't, you know, go ahead and get your buyers, excuse me, completely pre-qualified. You know, so it's not just oh, this is a pre-qualification. No, I have a loan commitment. All I need to do is get the appraisal and the title work on the property, and we're ready to close. Or better yet, have them go borrow money from their Uncle Bob, and then they'll get a loan after they buy the house and then pay him back. You know, he's got millions of dollars in his 401k, you know, and pay him for that privilege. And, you know, just, you know, make your offer so compelling. I looked at a house today and took a buyer over there, and, you know, she's in a situation where she's just going to pay cash. And it's about 725 is what they're asking for it. I said, to buy this house, you're going to probably pay anywhere between 750 and 770. That's just the way it is right now. You know, I mean, now this house needs a lot of work, so it'll probably more in the 750 range, but she's going to have to pay more than what the list price is. Just where it is. Why? Because there's going to be other people that are willing to, you know, in fact, tomorrow is the day when the listing agent is called for final and best offers. And I don't know, you know, she probably won't buy that one. It's just too much work, but she has cash. Well, when we write her offer, it's going to be a large earnest money. It's going to be a situation where a part of it becomes non-refundable the day they sign the offer. And it's going to be a situation where we don't have any contingencies. You know, it's just what it's going to take to get a market. One of my sons just bought a house in the Avenues, paid almost 900, about 910, and it was listed for 50 grand less. He paid 50 grand more than what they were asking for it. That's what it takes to buy a house right now. If you're not working with the buyer that's willing and has the ability to do that, well, I want to get an FHA and a loan, and I want the seller to pay, you know, all the closing costs, and I want, you know, okay, if you have a buyer like that, your very best chance of maybe getting them a house is a new home. You know, take them to a builder, and they'll write the contract. The builder will, you know, overcharge, and he'll pay all the fees and whatnot. But even so, It's taking so long to get a house done, and it's costing more than they thought, and the houses are worth so much more by the time you get them done. There's some builders in this market that are refusing to close. So sorry, I'm not going to close. To prevent that problem, you might want to have a larger earnest money deposit, because if you have a bigger earnest money deposit and the seller defaults, then they have to match that. They may think twice about trying to rip your buyer off, and I mean, they had it under contract for 600 grand, and but he knows he could sell for 680 right now. So he wants to tube that deal and take the 680 from any one of a dozen buyers that will buy it for the larger price, and it'll probably appraise. And even if it doesn't appraise, they'll pay over the appraisal if they have to. It's just that kind of a screwy market. Now, I had an agent call me the other day. She was all upset and in tears, and she says, "I'm so tired of working with buyers. I keep submitting all these offers. We never get one." Well, here's some tips to make your offer a little bit more compelling. But I want you to understand, she'd done 8 offers, and they weren't even in the running to get it done. So, but I want you to understand something. Out of all those 8 deals, there's one agent that always won. And who's that agent? The listing agent. There are a number of buyer's agents. I mean, when you're throwing in your hat in the ring with 8 other offers, you got a 1 out of 8 chance of getting it, unless it's really a compelling offer. But the listing agent always wins. So in this market, is it better to work with buyers or sellers? Tell you the truth, it's always better to work with sellers, because the person that controls the inventory, whether it's a severe seller's market like it is today, or in some markets is a severe buyer's market, that the person that controls the inventory always wins eventually. It's just you have to have more listings. In this market, you're lucky to have 5 or 6 listings. I mean, if you've got 5 or 6 listings all the time, man, you're making 250 grand a year, maybe more if they're in the higher price ranges. If you're lucky to have 2 or 3. Okay, Elsa, Dan, what's the question from Elsa? Do you think that when the
mortgage forbearance extension and the eviction moratorium expire on June 30th, it will affect the Utah housing market a lot?
We could have a short bubble burst. I go round and round with this with my real estate friends and buddies, and like Chris Crone and I've been arguing about this for a while, but things are the reason why things are getting so screwball is the fact that we didn't build enough houses. For about 5 years, we weren't taking out enough building permits. Now we have other reasons, the fires in California and some of the political situations. People are fleeing California. They're just sick of it. I mean, many people are getting burned out. There's water problems. There's all kinds of issues. And so they're saying, California was once a wonderful place to live, and now it's not. And so they're let's go home to Utah. That's where the grandkids are anyway. And so they're packing up and coming home. We always see that things get screwy around the country, and everyone wants to come back to Utah. I even had a really good friend of mine who lives in Washington State call me just a few weeks ago. We're as close as brothers. We've toured all over the country together doing seminars, and really close personal friend. And he's not LDS. He's never lived in Utah. He doesn't have any family here other than me. And I'm not really family. We just think we are. And so he called and said, and I'm getting real tired about Washington here. I don't, when we had all the fires and problems and turmoil downtown in Seattle here not too long ago, he said, I'm just getting out of here. He says, I want to come to Utah. Where should I look? Utah's perceived as a safe place and a wonderful place to live. And so a lot of people want to be here. Now, so my point is, we have more buyers coming into Utah than we have houses to sell them. And so controlling inventory is a sure bet. You're always going to get it sold. Now, the one we looked at today was hammered. It'd been rented for 3 years and the seller didn't want to fix it up, but he wanted in the listing remarks from the seller, was Phil Craig, who's a buddy of mine who has a listing. Phil said, seller wants a strong deal. He doesn't want it to go under contract and have a fall through and then try to resell it. He wants it done right from the beginning. So how would you write an offer to convince the seller it's a done deal? Number one, all cash, close in 7 days, big earnest money, and a letter from the bank that says the money's on deposit, or better yet, you've already submitted the money into into a title company. It's already sitting at the title company waiting to have your name put on the check. 7 days will close. No contingencies. That would be a slam dunker, and that's what this young lady wanted to do, except she thought the house needed more work than she wanted to take on. So she wants something a little bit more pristine. Chances of her getting it in that price range, or she's going to have to pay another 100. Anyway, but she has money to do that. So the point is, work listings. Always work listings. Good market, bad market. What's a good or bad market? Buyer's market, seller's market. It's always a realtor's market. We just take our percentage off the top. So that's my little talk for this evening. I do want to encourage you to get a copy of my book. And you can get it for free. You could get a copy of this book for free. I've got it on my website, rickroller.com. You go to rickroller.com and you'll find a place where you can get an audio version of the book, or you can get one of two different digital copies. You can get one that works with your notebook, or you can get one that's Kindle. So, and now why this book? Because this book is written by, Chris Crone, my good buddy Chris, and me. I'm on the bottom there. And I told you it was a head game. Well, this book talks about the 9 laws of conscious creation. You've got to get your head straight on where you're going in this business. This business is like walking on jello unless you build a firm foundation. And the foundation has to come in here. It has to be in your head. When you walk in to get that listing, and it's extremely competitive right now, you got to have confidence that you're going to get that listing. It's all in your head. You've all heard about the movie The Secret and the law of attraction. Well, that's one of the laws of abundance, but actually there's 9 of them, not just one. Yeah, if you want the gorgeous gold embossed hard copy, come to one of my classes. I'll give you one. My classes are free too. Just show up. Last week I did a 3-hour mandatory residential class, and Dan and I are going to start doing live classes again. That one was actually done with the title company in town, but get the digital copy now and then come to one of my, you're going to have to come to a 12-hour new agent class for your first renewal. I would suggest taking that 12-hour new agent class sooner, not later. Why? Because you're going to cover a whole lot of things in that 12-hour new agent class that you've got to know to make it into business. So why take it, 11 and a half months after you've been into business when you come up on your 2-year renewal? The question is, when do I have the classes? Normally there's a calendar on my website, rickroller.com, but there's nothing on there right now because we haven't rescheduled anything for after COVID. I'm going to do a 12-hour new agent class, which will take a full day, 8 in the morning till about 5, and with the lunch break. And then we're going to have, and then another half day, the next day. So we do all day, and then usually the morning of the next day. And I'll be doing one of those in June, not in June, in July, between the 4th and the 24th. I've got to pin that down. But you have my phone number. You have my website. We'll put a listing on the website when that class is, and I will I'm not sure. I was doing them down in Utah County. I did a few during COVID anyway. We did them in Utah County. They're a little more liberal down here. I did a real big one in Cedar City for the board down there, and we had about 40 people in that one. I gave them all a book, but Dan is extremely committed to get you through this exam, but he's also committed to have you put in a position where you can have a successful real estate career. And so am I. And, I make my time available to you. People say, well, why do you do that? And it's because people help me. They helped me when I got into business. And, man, I was broke. I was driving a Volkswagen Bug. I had a young baby, a boy, and my young bride, and she wasn't working. She's taking care of our child. I mean, I had to make it or die. And I made it. I sold 54 houses and made Rookie of the Year in Grand Junction Board of Realtors. My second year, I sold 98 houses. And there's nothing special about me. I just work real hard. I can tell you what to do. My specialty in working with new agents and mentoring new agents is helping new agents. If you're an existing agent and you want to change things up, we do a lot of fun too. I love real estate because it's creative. This is, I just saw this up here. This is a QR code. Have you ever been driving around town and there's a listing and there's a brochure box and they're always empty? So dang frustrating. I don't use brochure boxes. This is an Avery paper label. It's kind of a vinyl coated thing, and you can print this on your your broker's laser printer if you don't have one, and you can peel this off and stick this on your sign. Now the QR code takes you to a video. The video is you telling them about the house. And I go through that in my 12-hour new agent class. We got a little segment on that that I've worked in. But, we give you, usually I'll bring in one other instructor. Sometimes I do them all myself, but I bring in a videographer specialist. Sometimes I bring in a lawyer and we talk about contracts, or if they're not available, I just do the class. But it's all about getting your head straight and getting out and making it happen. It's 12 hours. You have to take it from somebody. You might as well take it from a guy that's not only been Rookie of the Year, but has developed 8 other Rookie of the Years in different jurisdictions and hundreds of other agents who've won awards. And man, you can't beat the price. It's free. So anyway, that's my 2 cents for tonight, but please call if you have questions or concerns. I really don't want you stressing out over one particular concept when you could just pick up the phone and call me and, say, Rick, what about this or that? I said, well, first of all, if you're looking at land description, there's only 3 questions that they have in the database and they are this, and that. Okay. Secondly, just look at it this way, not that way. And oh, I get it now. And you're done. And you're not trying to find a video or trying to read the manual for the 5th time or whatever, which is all good, if you study, but whatever, take advantage. I'm offering it to you. I don't know how much longer I'm going to do it. Dad wants me to come to Colorado and stay with him in a mountain house, or go down to Sedona with him. So we'll have to see how that pans out. But we can keep in touch by phone or live. Okay. All right. Appreciate you guys. Thank you very much, Ben. It's been a real pleasure working with you. And guys, remember, you can pass the exam and you could make this into a career. You could make this into a career, folks. It's going to create a legacy for your family. Thanks for being here.
Thanks, Rick.
You bet.